Welcome to the Court Gallery. Today, we're diving into the bizarre world where domestic disputes meet bird law. First up, a landlord is at his wit's end, claiming his roommate's large, free-roaming bird is turning his home into an unsanitary disaster zone. He wants them both out, but the roommate says it's all just a big misunderstanding. Then, we jump into a nasty property dispute that's already resulted in an assault conviction. The plaintiff is back with new video evidence accusing his neighbor of sneaking into his property to steal his Birdbath. Can these judges untangle two separate feathery feuds? Well, we're about to find out right here in the Court Gallery. Because, never forget, every day in the USA, people find themselves in court.
Now, this is William L.G. Brewer and Preston Anthony Christie versus Mark Fowler.
Yes,
Do we have Mr. Fowler with us?
Yes, sir.
Okay.
No.
Mr. Brewer, could you please go forward and state your case?
Yes, Your Honor. I'll give you the Reader's Digest version. Late last year, Mr. Fowler informed me that his current residence was being torn down and he needed a place to stay until he could find another accommodation. I had room in my house, so I told him he could stay at my house in a roommate status, not a formal tenant with a lease, under two conditions. Number one, he doesn't trash my house. And number two, him and Preston Christie, the other roommate, come to some sort of agreement about paying the bills. He has failed on both counts. He has a very large bird. I'm not sure the species, but it's about the size of an African gray. If there's such a thing as a housebroke bird, I've never encountered one. And he lets it run free. The bird craps on everything, everywhere. It's a very unsanitary condition, and I've complained about it before, and he doesn't seem to think he needs to do anything about it. As far as the bill thing, they did kind of come to some sort of arrangement, I guess. I don't know what it was. That was between them. But Mr. Fowler has not been paying his share of the bills on time. It seems like every month I get a late notice, and almost every utility at one time or another has been disconnected because of his refusal to pay the bill. The power's been shut off, the water's been shut off, the TV and internet has been shut off. The main thing I'm concerned about, well, of course, that doesn't do my credit rating any good. But the main thing I'm concerned about is his stupid bird crapping on everything. I mean, it's a very unhealthy, unsanitary, almost uninhabitable condition. And the other thing is birds have a unique and very obnoxious to me odor. And his bird stinks up the house, for lack of a better term. And I'm seeking a writ of possession or whatever it's called. I don't want any money from Mark. I just want him out of my house. And I believe also the other roommate, Preston Christie, has a few words to say on the issue too.
Is Mr. Christie with us?
Yes, Your Honor.
Okay. And what is your position with regard to this matter, Mr. Christie?
I am once again, like Phil Brewer just said, the roommate to Mark Fowler. I do have a formal testimony for you, Your Honor. My name is Preston Christie. and I'm requesting that the court grant the eviction of Mark from the property. I did not make this decision lightly. I have attempted to maintain a peaceful living situation, but Mark's behavior has made it impossible for me to continue sharing the residence with him. During his time at the property, Mark has engaged in conduct that has caused serious concern for my safety and well-being. Most importantly, he made threats towards me that I took seriously enough to contact law enforcement. As a result of these threats, I no longer feel safe living in the home while he remains here. In addition to the safety concerns, his actions have created ongoing conflict and instability within the household. The living environment, has become stressful and difficult to maintain, and I do not believe the situation can be resolved without his removal from the property. I am not seeking this eviction out of spite or retaliation. My goal is to simply protect my safety, preserve a peaceful living environment, and regain stability in my own home. For these reasons, I respectfully ask the court to grant the eviction and allow me to move forward without continued fear of confrontation or threats. Thank you for your time and consideration. Respectfully, Preston Anthony Christie.
Hey, Mr. Christie, when did you first meet Mr. Fowler?
I met him around August of last year, 1 month after my grandmother's passing. I moved back in to help my grandmother out because she was struggling on her own. And long story short, she got hospitalized again, and things weren't going that great. I quit my job. I moved out of my apartment. I did a lot. As far as helping her, I did my absolute best, which unfortunately wasn't enough.
So when did you first, let's put it this way, was Mr. Fowler your roommate before you moved to this location?
No, sir.
And this location is 10176 Ware Loop Circle, is that correct?
Yes, sir.
Okay. How long had you been there before Mr. Ware became involved in the location?
I'd say roughly to 3 to 4 months.
And okay, thank you. I will ask, just to try to clear something up first before I recognize Mr. Fowler. Mr. Brewer, do you live at that location, sir?
It's my primary residence, but right now I'm staying with my brother, who has a ranch north of Rising Star, which, if you don't know where that is, it's about 65 miles southeast of Abilene. In the past, I don't know, 3 years maybe, he's had 3 strokes, 1 major and 2 minor. So I'm staying with him on the ranch, helping out, doing the chores, working, cooking, cleaning, that sort of thing, and helping with the rehab. He's kind of trying to learn how to walk again.
How long okay, let me ask it this way. Do you have title to the location 10176 Ware Loop Circle?
I do, sir. I've owned that. I purchased it from my mother, I want to say in 1999. So I've owned the property for a few years.
Okay. Thank you. Okay, Mr. Fowler, one, I'm going to give you the opportunity to tell me whatever you need to tell me. Before that, though, do you have any questions of first Mr. Brewer? And so if you have them, please ask them now.
Okay. Yes, sir. But the only thing that concerns me is, he said that I threatened him and he called the cops. They came out, and when they came out, he told them that I had threatened to shoot him, which I had never threatened to shoot anybody, which was a total lie to them, so they would come out. And that aggravated me because I'm not that kind of a person to begin with. I'm very laid back. And I have never threatened him, but he has threatened all kinds of ways that he's going to hurt me and do this and this and this to me. But yet, you know, I'm like, what's bringing all this on? I mean, I'm trying to coincide with him. You know, we had an agreement to pay the bills, and yet, you know, like this last time, he taped the bill to my door, but it was a bill and it said it was already being ready to disconnect. And so as soon as I got paid, I went down and paid it. And then another when the water got cut off, you know, that was supposed to be part of his bills, and it got behind and he refused to pay it for several months. Then I finally went down and paid it because it was getting disconnected. So I went down and paid it, got it taken care of, and got the water back on. But now he's saying, well, this is all you got to pay, is that he handed me the electric bill. And so I was like, okay, that's fine. So it's been, you know, he said, she said thing. And, you know, when he tells me, you know, I got a bill, you know, fine, I'll pay it.
Okay.
I mean, I might not be able to pay it right that moment because of, you know, my paydays.
Well, sir, let's, I understand your roommate or housemate, person living in the same place, you and he have some disagreements or at least issues with when things get paid.
Correct.
And also with, the allegation of a, threats. But with regard to Mr. Christie. However, the person who is the owner of the house is Mr. Brewer.
Yes, sir.
And he has stated that essentially he doesn't want you there because of your bird. It's his house.
Yes, and correct. Ever since he told me to not let her roam free, I have not been letting her roam the house. She stays in her cage unless I take her with me somewhere.
Well, no.
And I have cleaned up a lot of the mess that she made.
Well, understood.
And
But
trying to make everything back to the way it was.
it is still his house.
Correct.
And other than the utility payments, which are not rent, it's an entirely different thing than rent.
Right.
No rent is required. The only thing that is required is not you and Mr. Christie getting along, but Mr. Brewer being comfortable with you being there.
Correct.
Now, the I'm going to ask Mr. Brewer one last thing. When was notice to vacate given to Mr. Fowler?
It was on May 15th,
Okay.
Your Honor. And Mr. Christie, I sent Mr. Fowler a text message because at that time I didn't have access to a printer on the ranch. So Mr. Christie followed it up with a written letter to Mr. Fowler. And I'd also like to refute Mr. Fowler's last statement about, paying the rent or paying the utilities. The electric bill is due on the 6th. On the 10th of June, I got an overdue notice. And then the next week, I got we're going to disconnect you notice. So, what
Okay,
he's
well,
saying is
which
not
of the,
entirely true.
you've got two people working on that issue unsuccessfully. Wasn't just one you were looking to pay it, but both, or whichever. As long as but this is a tenancy at sufferance. I understand that you said thank you, but goodbye. And as such, you're not seeking any monthly rent because none was there. In an eviction, there is no provision for costs such as electricity and that, unless it's part of a lease. So
I'm not seeking any monetary compensation.
that
but
I understand.
Mr. Fowler is refusing to leave, so I'm going to need a writ of possession or whatever it takes to get a constable
Well,
to come in here and usher him out.
This was understood, sir. I'm gonna go ahead and order possession and court costs and nothing further. Thank you very much.
Thank you, sir. Am I excused then?
Sir?
Are we done? Am I excused, sir?
We are, sir, and thank you.
Thank you, Your Honor. Bye.
Excuse me, Your Honor. I just wanted to inform you just a little bit more about the things that have happened on the property.
Sir. What I have just said is I'm gonna sign a judgment saying that Mr. Fowler has to leave. There it is. There's nothing else. I'm not in it to say who said what to whom as it went along. The real issue is Mr. The actual owner's position in this case. He's made that clear. And why? Thank you.
Yes, Your Honor. My apologies.
None necessary. Okay, thank you. Take care.
Thank you, Your Honor.
Okay, I believe that leaves us with number 1, 24-2-13-1708, Richard Smith, represented by Mr. McCreary. Good afternoon.
Afternoon, Your Honor.
And then I have Jenna Harden and Joseph Jensen. And who will be representing them today? Go ahead.
Your Honor, I am here, but I would like to have a set over so that my attorney can attend.
And who is your attorney?
Patrick.
Mulaney. Okay. I see Mr. Stearns online.
Oh, is he?
Yeah. Ma'am, hold on a second. Mr. Stearns, go ahead.
Good afternoon, Your Honor. I'm David Stearns, and my intention was to proceed, but if my client has other ideas, maybe she can shoot me an email, but I believe we're ready to proceed.
I'm ready to proceed.
Okay. And Mr. McCreary, are you ready to proceed?
Yes, Your Honor.
Okay. All right. As plaintiff, go ahead.
Thank you, Your Honor. What I've provided to the court in support of this motion for a preliminary injunction, really, obviously, it has to encapsulate the case. And so I've given the court some exhibits that I think are helpful to really just walk through as we talk about the various requirements for a preliminary injunction. And I assume the court has reviewed my Exhibit A with the markings on it, the overhead aerial picture of the properties.
Yes.
It's clear to see in that picture that a couple of things are present here. We have the driveway easement, which is sort of top center with the orange line, and that easement runs along the east boundary and goes down to where you can see owned access to east parcel. There's a jog in the line there that includes direct access. That's important in terms of whether or not there's any need for an easement or a prescriptive easement across my client's property. The row of trees and so forth that are shown, unfortunately, the green didn't show up that well in the copies, but I assume the court can see where it says row of trees and there's the orange line. That orange line tracks where this row of trees that Ms. Harden refers to. I don't know that she planted them, but that area is the area that my client has operated in for 20 years. The area south of that towards his house, where you can see that it says garbage cans, etc., and the Smith house. The driveway from that easement in the north central part of the property works its way down, and you can see the disputed driveway area that I drew in there in orange on Smith's property. Just wanted to be sure the court was oriented to those things before taking off. So in order to get a preliminary injunction, there has to be a clear legal or equitable right. And of course, the defense has poured everything into claiming that they've been using this property for over 20 years in an area that has been nowhere near where my client has been maintaining it and so forth. It's the testimony by Ms. Harden is contrary to the aerial photographs. And so that's why I would turn to Exhibit A, page 2, which is the aerial photograph from 2005. And you can see in that picture, the house marked S is the Smith house. The house marked H is the Harden house. And you've got this area, this bank just north of the Smith house that is obviously dirt colored, not ivy colored, some 3 years after Ms. Harden claims to have planted ivy in that area. So that doesn't really hold true in terms of the area north of Mr. Smith's house, that Ms. Harden was somehow engaged in some form of growth of ivy in that area. Then you turn to the next page, which is page 3 of 6, and same markings, S for Smith and H for Harden. You can see just north of Smith's house, there's a substantial distance from the north eave of his house, the north edge of his roof, that's a light tan color, which I don't believe anybody will allege that the ivy that Ms. Harden claims to have planted was light tan. This is bare dirt, an area that my client claims to have maintained. And at this point, he's 7 years in to keeping that area clear. And really, if you look back to page 2, you'll see to the northwest and on page 3, to the northwest of Smith's house, there's an exposed bank that runs along the northwest boundary up into that corner that has nothing on it, all the way into 2012. Then we turn to page 4, and page 4 continues to show that northwest bare bank up in there, and the area north of Mr. Smith's eaves continues to have a bit of a line there where he's been maintaining, and it still remains a bit tan in that area. That's in 2018. So now we're 13 years into Mr. Smith's maintenance. These parts don't comport with Ms. Harden's testimony that she had in her declaration. Mr. Smith maintained those areas and has a block wall in those areas, as he testified to in his statement. There is some greenery to the north of the tan areas, but at this point, Mr. Smith essentially has proven adverse possession with that area. That's in 2018. Then we provide the 2021 picture. It appears to be more of the same with the northwest area and the areas north of his eave. And then on page 6, there's even more maintenance in 2024 that's been performed by Mr. Smith. Those pictures are contrary to Ms. Harden's declaration and consistent with Mr. Smith's declaration. So in terms of showing a clear legal or equitable right, we concede that the property line according to the deeds is, of course, north of that area, along where the trees are planted. But Mr. Smith has maintained that area on a steep bank below those trees. He's never seen Harden or her husband in that area. And so that's the clear legal or equitable right based on merely the quiet title action. Another portion of this, though, deals with a clear legal or equitable right to peaceful enjoyment. And Mr. Smith has been assaulted while simply going to get his mail. Ms. Harden was convicted of that assault, and we provided the court in Exhibit B with the information from the court that indicates the sentencing was deferred on her conviction. And number 3 in that box down on the bottom half of the page says, obey the post-conviction no contact order set out with this sentence. It's not that often in a case involving a boundary dispute that someone is convicted of an assault of their opponent and is given a no contact order and has the audacity to come in and walk right next to his garage, take his personal property, and carry it around back through her property, and then take it down what she alleges is her easement rights and throw it off into the woods. I would submit that Mr. Smith has a clear legal and equitable right to peaceful enjoyment of his property, not just from his rights under the general law, but under the no contact order set out within the sentencing and the notion that this was under a matter involving a conviction for assault. That portion of this seems undisputable, and Mr. Smith should have that peaceful enjoyment. I think it's also interesting that when I pointed out on Exhibit A, page 1, that Ms. Harden has direct access, the defendants have direct access to that east parcel, I believe it's parcel 4. That direct access is contrary to what Mr. Mullaney provided as an exhibit in terms of, I guess, the legal point or factual point that was being made by raising that. So Mr. Mullaney's declaration, Exhibit A, part of the Cowlitz County Department of Community Development letter that was sent back in 1979, he highlights, unless lots 3 and 4 have direct access to the private road, the lots would have to be considered landlocked and the short plat could not be approved. Well, lot 4, which is the east parcel on my Exhibit A, page 1, is not landlocked. It has direct access to the private road. That's what that jog in the line where it says owned access to east parcel is indicating. So for Ms. Harden to come into this motion and say that that my client doesn't have a clear legal or equitable right to his driveway, and that she does not have the right to march down his driveway while restrained by a criminal restraining order, and throw his bird bath into the woods that she collected from alongside his house, it flies in the face of reason. There is clear access there. She has no need to walk through his property. This was intended to be an act of intimidation of Mr. Smith after she had assaulted him. Second, we have to prove that there's a well-grounded fear of invasion of that right. Well, Mr. Smith has been assaulted by Ms. Harden, and there is a restraining order, and a well-grounded fear would come from her walking onto his property right next to his garage, and then taking his property and walking through her property apparently, and then come walking down his driveway, all caught on video. And Mr. Smith is supposed to be able to go to his property and experience the comfort of knowing that others aren't going to invade that property. And he has a well-grounded fear of invasion based on a conviction for assault and the fact that she entered the property. Now, I don't believe there's any meaningful dispute of the pictures that appear after the sentencing information that we provided, which are Exhibit C. Exhibit C shows the side of the north edge of Mr. Smith's house. It's his garage area where the trash cans are. You can see that he has a hose hooked up there and some hose on the ground, and there is the bird bath before Ms. Harden removed it from his property. To get to that, it's interesting to sort of contemplate how Ms. Harden arrived there and how she got out of there. There didn't appear to be evidence that she climbed down through the ivy. She would come past this bank in the northwest corner that you can see in the distance beyond the garbage cans. That's part of what I showed you in the pictures, the aerial photographs from 2005 all the way through 2024. That's an area that Mr. Smith has exclusively maintained. And then you've got his block wall. And so she came in and she took his personal property from this location, that close to where Mr. Smith lives, after assaulting him and having a restraining order against him. Then Exhibit D shows where she threw the bird bath down into the woods. And then Exhibit E are the pictures of Ms. Harden walking with, on number one, walking with the bird bath in her hand. And then number two, she's off of the driveway that apparently she claims is an easement onto what is exclusively, without any even question, Mr. Smith's real estate. She's not on the road anymore. Now she's just on his property, not an area she even contends that she's entitled to be on. Then Exhibit F is a picture of Ms. Harden in the brush in that northwest corner that I was showing the court in the aerial photographs, the tan patch in the northwest corner from Mr. Smith's home. And she's out there with a shovel, and I'm not sure what Ms. Harden planned on doing in that space or why she would be down there in the disputed area, but Mr. Smith is entitled to some peace and enjoyment of his property during the pendency of this case, and here she is in a spot that is somewhat intimately his space. It's his backyard. Then you can see in Exhibit F, Ms. Harden walking away from Mr. Smith's backyard. Apparently the camera didn't catch her while she was fully in his yard, but she clearly is just walking out of it and is partly in it there. Exhibit G is another day after the restraining order was entered where she's walking on his driveway. So in terms of a well-grounded fear of invasion, she's been convicted, she's been restrained, and she continues to enter Mr. Smith's property. With regard to the damages from that, I mean, number one, obviously, there's fear and concern over further assault. Once you've been assaulted by somebody, you don't know what they're going to do next. You wouldn't expect them to show restraint, and here's Ms. Harden not showing restraint in a way that is sort of flaunting the court's order in that regard. His personal property was removed. She took it off of his property and onto her property, and then brought it back and threw it somewhere in the woods. That unpredictability creates a legitimate fear and creates damage for the lack of security Mr. Smith feels in his home. At this point, the bond requirement should be waived. It shouldn't be necessary for Mr. Smith to post a bond to stop Ms. Harden from committing acts of misconduct. So what we're requesting is the court enter the order as requested, and the the list of requests that we make are not unreasonable. They're not outlandish. It's just a straight down the line. Don't come on to Mr. Smith's property or the disputed area. The disputed area is not going anywhere. We can't build a gazebo on it and say it's been there for 100 years. There's pictures. There's all sorts of documentation of where things are at. Ms. Harden has no business other than to harass Mr. Smith in this close proximity to his house. She has access to the east lot. There's no reason for her to walk down his driveway and flaunt the restraining order. She shouldn't be touching or damaging or removing any of his items of personal property. She has a lawyer. If she was worried about the Birdbath, have her lawyer send me a letter and we'll communicate about it civilly. No communication, contact, or harassment of Mr. Smith, no making any gestures or projecting sounds, that sort of thing. We're just asking that Mr. Smith be left alone on his property. And we believe that each of the elements required for a preliminary injunction to that effect have been met.
All right, Mr. Stearns, for defendants.
Yes, good afternoon, Your Honor. I think on closer inspection of Mr. McCreary's arguments, the court's going to find that Mr. Smith hasn't met any of the requirements to establish his entitlement to a preliminary injunction. So I think, first of all, I should comment, I don't know if this was an issue on the scanning on our end or what was served to us, but I can't make out any color on the exhibits to the motions. So I'm not really sure what areas are brown and which are green per Mr. McCreary, but I would just point out that I think it's sort of irrelevant either way, and it's a pretty thin reed on which to rest his entire claim to having adversely possessed the property. I think in Ms. Harden's declaration, I think she makes clear that the ivy was planted, but it obviously is going to take a while to establish itself. So it's not factually inconsistent to say that ivy was planted and then that there might still be some dirt visible from satellite imagery that I presume is what's shown in the exhibits. I don't know that we know exactly where, what elevation that these photographs are from or how color is depicted on them. But either way, I think it raises a question in my mind is if the slope is dirt, as Mr. McCreary is now saying, I don't know what it means then to say that his client was actively maintaining it. And so as far as I can tell, there are two reasons that he says his client's entitled to, or why his client has shown that he has a likelihood of success on the merits of his adverse possession claim. One is that you can see some dirt in the satellite imagery. And two is that that Mr. Smith has personally never seen my clients in that disputed area. And I think so first of all, the lack of color, I think, is a particularly weak basis on which to make that claim. And the fact that Mr. Smith didn't actively see them there isn't at all surprising because, as my clients testified, for most of this time, every time my client saw the side of Mr. Smith's house that goes right up against their property line, he had his blinds drawn to that side of the property, so he wouldn't have seen them. And furthermore, our clients just have to show that they made use of the property that's typical of what a normal property owner would make use of such property. And I think most people who own a steep slope of land aren't going to be throwing picnics on that slope. They're not going to be playing croquet on a steep slope. My clients did exactly what any reasonable property owner would do, which is to plant ground cover to keep it secure and to keep it from eroding, and planting a row of trees at the top to ensure that the slope remains stable, and periodically looking at their property. But the fact that they didn't happen to physically be there at the time that Mr. Smith looked out and saw them doesn't do anything, I think, to show that they weren't exercising the kind of ownership over the property that a typical landowner would. And at any rate, I didn't hear anything from Mr. McCreary disputing the fact that very soon after Mr. Smith moved into his property, my client spoke with him and gave him express permission to trim back the ivy which I guess either does or doesn't exist, depending on which way you understand Mr. McCreary's argument that you just heard. But to the extent that Mr. Smith was maintaining the ivy, it was with my client's express permission over time to cut back the ivy that would have been growing onto his property. And once there's permissive use, it can't be the basis for adverse possession. Again, with the case that we cite in our opposition, unless Mr. Smith can prove or demonstrate somehow that permission ceased and that his adverse use continued. And there's nothing in the record that Mr. Smith has provided either that acknowledges the permission that my clients gave or that permission affirmatively ceased at any point in time and that his use continued in an adverse way after that point. So I think as to the disputed area, I think Mr. Smith is a far cry from having established a likelihood of success on the merits of his adverse possession claim over the disputed area. As to the easement portion of it, we detail in our brief, I think, 4 different theories under which we believe that there is an easement. There's an express easement that was on record that Mr. Smith had record notice of when he purchased the property, and he would have had actual notice that a driveway extended onto his property and connected the road to parcel 4. I think it's very important to understand, and we cite cases on this, and the law is very clear. The requirement is not absolute necessity for, at least for an implied easement. The test is whether there's reasonable necessity, and Mr. Smith hasn't shown any evidence from anybody who knows how to build a road to say that small little jog in the property lines creates an area where Lot 4, which is the dominant parcel that we're trying to protect here with its easement, can actually build a road that has access to the right-of-way leading up to the public road. No contractor has said that's terrain that the road can be built on. I don't even know how, from the evidence that's been submitted, I don't even know how wide that small overlap is between Lot 4 and Lot 2. And at any rate, what we did show is that the planning department said at some point when some version of the application was submitted for the original subdivision in 1979, they said, you need to be explicit about where this easement goes that's going to ensure that Lot 4 has access to the public road. And the subdivision that was subsequently approved had an easement that extended 510 feet down from the middle of the road to the north, which is further than the eastern edge of my client's property, meaning that express easement extends down into Mr. Smith's property. And my clients, as the owners of parcel 4, have a right to use that express easement to access their property, which is what Mr. Smith is trying to prevent with the motion that he's brought and the order that he's seeking. There are multiple points in Mr. Smith's declaration where he will make a strategically vague claim, such as, oh, I put the barrier up, but he never says that it was up for long enough to have extinguished any easement that exists by prescription. My clients have submitted declarations showing that for the decades that they've lived at their house, they have used the driveway, and the years since they bought parcel 4, they and their family have used the driveway to access parcel 4. Their children have grown up using that driveway to access parcel 4, where they'd go and play on the deck structure that we showed in the exhibits to Mr. Jensen's declaration. There's simply nothing showing that easement that exists any sort of way you want to look at it, and which exists, would have been apparent to anybody buying the property that Mr. Smith bought, Um, Anybody who bought that property would see that there's a driveway that goes across their land, and there's a right of way that then proceeds on to lot 4. Everybody would know that the owner of that lot is going to be able to use the driveway to access their property. It just would have been apparent from looking at it. Onto the big show that Mr. McCreary is trying to make of the conditions surrounding the suspension of the sentence from the dispute that arose between my client and Mr. McCreary's client. I think that's just fundamentally conflating what the question is before the court today, which is, does Mr. Smith have a likelihood of succeeding on his claim to permanently take ownership of either the disputed area or the easement? He's conflating that with a finite condition in a completely separate case that arose from a dispute. I'm sure my client would acknowledge this was not her finest hour when she had a dispute with Mr. Smith. The fact of the matter is they just don't get along. And there's nothing in that case that had anything to do with altering the property lines between my client's property and Mr. Smith's property. It didn't have anything to do with dispossessing my clients of their right to use the easement to access their parcel 4. It doesn't have anything to do with giving Mr. Smith title to the disputed area, which is what we're talking about today, and which is what Mr. Smith is trying to seek to prevent my clients from accessing, is their property that is within their property lines. And nothing in the order prevents my client from taking refuse that Mr. Smith has left on her property and moving it back to his property. Mr. Smith bought a house that comes within an outstretched arm's length from his neighbor's property, and he can't just leave refuse on his neighbor's property and expect that refuse to stay there and then come to court complaining when his neighbor moves that broken bird bath back onto his property, which is all that's been shown here. And I believe Mr. McCreary said that Exhibit C to Mr. Smith's declaration showed the bird bath. I'm not seeing a bird bath in Exhibit C. I'm seeing a few trash cans. And what my client's declaration says pretty clearly is that the bird bath wasn't on his side of the property line, and that for the first time since she's lived next to Mr. Smith, he put an object conspicuously on their side of the property line, which is what he's trying to effectively steal from my clients in this lawsuit. And there's nothing in any court order that prevents my client from making full use of her property. And that includes keeping it clear of garbage that her neighbor is going to leave there. And one more important point too is that the proposed order that Mr. Smith is seeking to enjoin both of my clients from using the property, and he's using a judgment that places conditions. If you're really bending over backwards as far as you can to read it in favor of Mr. Smith, it has nothing to do with Mr. Jensen's rights to use his property or anything. So to the extent that that's going to form an important leg of Mr. Smith's argument that he's entitled to relief in this matter on the claims that he's asserting here, it just doesn't hold any water at all, because it doesn't place any restrictions at all on Mr. Jensen, even though that's part of the order that he's seeking to enforce here. Beyond that, Mr. McCreary, I think, sort of glossed over the extent to which the proposed order goes drastically further than anything that he could conceivably be entitled to. He's trying to enjoin my clients from making any gestures at his client, from making any noise that might reach his client's property, That seems to be based on Mr. Smith's particularly acute sensitivity to the fact that my clients mow their lawn. That seems to really bother Mr. Smith, but obviously if you're living in a rural area, people are going to mow their lawns. They're going to have riding lawnmowers. This is nothing unusual. My clients are not doing anything that they're not perfectly entitled to do. And Mr. Smith's declaration in motion doesn't show anything to the contrary. So in short, I think that the motion just clearly falls short of everything that it would have to show to succeed on the merits here. It certainly doesn't show that my clients have invaded any property right of Mr. Smith's. It doesn't show that he's successfully adversely possessed this slope that goes to the north from his house, upon which my clients proactively planted ground cover to protect. And one factual note, just to make sure your honor's aware and oriented, I think as Mr. McCreary said, the property, if you look at Exhibit C, the property line actually goes between the retaining wall and the corner of the house there. So he called the retaining wall Mr. Smith's wall. It's not Mr. Smith's wall. That's a retaining wall that is at least in part on my client's property. And you can see that from the survey that the plaintiff attached to his own complaint. The property line clearly goes in between the retaining wall and the corner of his house. So I think that claim is just completely inconsistent with the record, even as presented by Mr. Smith. So I'm happy to answer any questions the court has, but I think that's sort of the main of our argument, that our clients are just as entitled to make use of every inch of their property as they always have been. Mr. Smith hasn't adversely possessed the disputed area. He hasn't really made any plausible argument that my clients aren't entitled to use the easement either that exists either because it's an express easement, it's an implied easement, it's an easement by necessity, and one other that's escaping me right now, but I think it sort of blends into the other one if I remember the case law correctly. But these are all easements that these are all theories under which the easement exists, and there's absolutely no factual basis to conclude that Mr. Smith has effectively extinguished the easement, which I think any fair reading of the facts would have to recognize exists.
Thank you. Mr. McCreary, back to you. And quick question before you get started is,
Sure.
As far as the behavior that you're seeking in the preliminary injunction, is most or all of that already covered in the criminal case, or is it just a do not go on the property of Smith directive?
It's I believe just a do not go on the property of Smith directive.
Okay.
Well, yeah, I would just stick with that. It's
There's no, I guess there's no formal criminal no contact order that says things like don't harass, don't
I think
contact,
it's primarily no contact and
okay.
don't go on the property, but
Okay.
yeah, and it says in the document we provided, obey the post-conviction no contact order set out with this sentence. So it is no contact.
Okay. Okay, go ahead, Mr. McCreary.
I guess I'm sympathetic to Mr. Stearns and what he has to argue and how he has to argue on behalf of his client, Ms. Harden. She in a boundary dispute, she's been convicted of an assault of her opponent, and to come through that and feel the need to refer to my client's Birdbath as garbage sort of speaks to what the expectations of Ms. Harden are of her counsel in this process. But the crux of this is, making an argument that a dirt slope is not something that is the result of maintenance. I mean, if you kill weeds, that's maintenance. And when you've killed the weeds, you have a dirt slope. And I'm not sure what the color confusion is between dirt and live vegetation, but rarely is live vegetation brown. The point being is that Mr. Smith's declaration is clear. Throughout his entire ownership, he has been the sole person who's maintained that bank. We're not here on summary judgment. If we were on summary judgment, perhaps Ms. Harden, by making her statements that she's given permission and that she's maintained the bank, which has never been seen and never been shown, that might avoid a summary judgment, but it doesn't get past the standard in terms of my client's clear and equitable right, not only to the ongoing use that he's made of that bank over the years, but his right to peaceful enjoyment. And where do you cross the line on peaceful enjoyment? What are his rights? And to the extent that we have some dispute over that area, his rights of peaceful enjoyment extend into areas that he's historically enjoyed peacefully. And there's no allegation by Ms. Harden that there are historic disputes or fights in that area. So, he has peacefully enjoyed it, and that's now been disrupted by the fallout of an assault conviction. I mean, my client's declaration would have said, Ms. Harden gave me permission to do things in that area. If that had happened, it never happened. That's why for 20 years he maintained the bank and testified that he was the only one who maintained the bank. That's just trying to confuse an issue by saying, hey, here's what my client claims. But in the end, Mr. Smith has that right to peaceful use and continuance of what he's been doing. Counsel's arguments suggested to me that somehow we're supposed to provide testimony about their ability to have a road when they have direct access to the easement as called for. Any express easement does not include the orange line on my Exhibit A that loops around towards my client's house. As described, it would go south, possibly over my client's line if that's necessary, but there's direct access. And that's shown on Exhibit A. My client in his declaration mentions Mr. Jensen and his need to aim the discharge of the mower towards my client's property, flinging chunks of things in that direction. That sort of, I mean, I suppose it could be just mindless, but it seems unlikely in the context of the juvenile nature of some of the dispute that's been going on from their side of the line. And so, on the whole, we have someone who was convicted of an assault who's now sort of trolling my client by entering his property and using the area as never used before that is now disputed. So we're asking that the court find that it's appropriate to enter a preliminary injunction that controls some of this activity that's just, it's only directed at my client. I mean, to be standing in the backyard with a shovel, to be walking around with his bird bath and flinging it into the woods. Unacceptable conduct, and it should be restrained through this injunction.
Thank you. So I want to thank both parties for the briefing. The pictures always very helpful in these adverse possession cases. I'm going to be really bluntly clear. I don't in any way condone the behavior that's been exhibited. I'm going to go through what I see as the facts. And when I first went through this case, what I noticed is, this is a case for quiet title that was filed in 2024, end of 2024. It's been amended over time. And, really what we're dealing with is the quiet title issue through adverse possession or prescriptive easements, and then the defendant's claim to an easement across the plaintiff's property. So, this case has been hanging around for some time as the days and the months go on. Typically, when I see these requests for injunctions, is at the very start of the case is filed, and the parties say to me, hey, like this case is filed and we need this injunction kind of to preserve the status quo as things move forward. We're pretty far down the road in the lawsuit, and so there doesn't appear to be a strong immediacy, but for the new thing. And that new thing that's happened is Ms. Hardin's behavior towards Mr. Smith, and ultimately resulting in this criminal case and this deferred sentence. And sounds to me like either a condition of no contact or an actual no contact order. And frankly, if there's an actual no contact order, and I don't think that was filed, but if there is, it typically would tell Ms. Hardin she can't do a lot of these things that Mr. McCreary is asking to be enjoined, making harassing gestures and things like that. There's also anti-harassment orders that I guess could be implicated here if a party were to file those. But I'm here on the property case, so I don't dispute that the things that have been talked about today could potentially be violations of her deferred sentence. They could be violations of the no contact order. They could be grounds for an anti-harassment order. I don't know. But my decision here today is limited solely to this quiet title, adverse possession, prescriptive easement action. And as is often the case, these are they said versus they said. They did this or they didn't do this. They did this or they didn't do that. And often these are very factual, credibility-based determinations that should go to a trier of fact. So, I can't sitting here today based on the pleadings make a determination that plaintiffs are likely to proceed on the merits. I don't know. It's not so top heavy that I can say that based on the record in front of me today. But even if I could, I do believe that the plaintiff has other remedies at law that have nothing to do with the property dispute that could give him this, peace that he's looking for. And I've outlined those things. So I am going to deny the motion for temporary injunction. I can't find, more likely than not at this point that the plaintiffs are prevailing just based on this early record. And by early record, I mean, it's not a summary judgment motion where, a factual basis is laid out by the parties. And I can't find an immediate risk of invasion of any clearly established right. Again, this case has been going on for quite some time. The new thing, the immediacy, is the assault. And I think there are remedies under the criminal case that can be addressed if that's an issue. So for those reasons, I am going to deny the preliminary injunction. If the parties prefer a presentation date, I'm happy to do that. I think although I'm typically every other week, I am on this docket next week, so we could set it, or I'm happy to do a bench order. Save everyone a little time and money. It's really up to the parties.
Bench order works fine for me.
Okay. Mr. Stearns?
Yeah, I think that works fine. I assume it will just be fairly short and sweet.
It will, yeah. If I do the bench order, obviously you have my record of oral ruling you can pull, but it would be a denial of the preliminary injunction.
Yeah, that sounds fine to me.
Okay. Anything else the parties want to accomplish today?
Nothing.
Okay.
Nothing.
All right. Thank you all.
Thank you.
Mark's giant bird was leaving massive droppings on the floor. So William served the papers and he walked him to the door. Then Jenna stole a bird bath from across the boundary line and chucked the heavy concrete right into a nearby pine. It is a complicated system full of feathers, poop, and claw. You will always lose the battle when you violate bird law. So keep your avian objects safe to